Welcome to the Jackson Kelly webinar, Emergency Response and Crisis Management. Before we start, I'd like to take a moment to address some administrative issues. For those of you participating from your computer, questions may be submitted using the Q&A pane located at the right side of your screen. Questions will be addressed both during and at the end of this presentation. If you have any technical questions during the course of the webinar, you may use the Q&A pane as well to send your question or send an email to marketing@jacksonkelly.com. The full presentation will be sent to you via a web link at the end. Included in this email will be a link to a voluntary survey, which we will use your responses to the survey to plan future webinars and events. All participants' phones have been muted and the presentation is now being recorded. Thank you all for attending. Today's webinar is presented by Kristen White of our Occupational Safety and Health Practice. Hello, thank you for joining today. What we're going to talk about today is emergency response and crisis management. So the way we're defining crisis is any form of serious or fatal accident that occurs on a work site. So it doesn't just have to be a fatality, it can also just be a serious incident. So as Raquel said, if you have any questions, please just pop them up while we go along, and I'll try to address them throughout the presentation and then also at the end. And we'll have you out of here in 1 hour. So most organizations take a lot of safety precautions on a day-to-day basis in order to ensure, the safety of their work sites. I mean, most people on this call are, somewhere in the safety and health industry. But what happens on the rare occasion is you have the extraordinary event that can occur, and that's when a crisis management plan needs to be put into place. So what we're going to talk about today is the issues for you to consider in developing your own crisis management plan. So we're going to go through some of the features that will be in that plan and some of the things to consider. And this is coming from our perspective, which is a standpoint of controlling legal liability and loss. So we'll mention some of the issues with HR, dealing with your employees, and that type of thing, because that should be part of your plan. But our focus here today is really on, kind of keeping control as much as you can on what your legal liability picture looks like. Because what we have found is that what's really important is those first 24 hours after an event happens, and how a company responds during those first 24 hours can really set the stage for the rest of the investigation and potentially any resulting violations. So the two big pieces that we look at to effectively manage an event is understanding the issues and the ramifications of your decisions. So if you choose to bring in legal counsel, if you choose not to bring in legal counsel, if you choose to bring in consultants, what are the issues being presented by the incident? So that's what we mean by this first bullet point, is the issues presented and the ramifications of those decisions. That's why having the plan in place helps you, plan for that as much as you can. And secondly, having this process in place which you can access and immediately implement as soon as an incident happens, and having the right people in place and knowing what areas need to be covered really helps you respond appropriately. And I think it also helps keep tension down, because everyone knows when this happens, stress levels go up. So having this process in place and the right people, to task on different items helps you. So first we want to talk about some of the elements of emergency response planning. So, what does this include when you're first looking at creating your emergency response plan? And the first is your facility and process assessment. So similar to, what you might call a job hazard analysis, you're looking at what kind of facility are you dealing with, what type of processes do you have. For example, for OSHA regulated sites, do you have PSM processes happening, because that's going to make your crisis management plan be different than someone who doesn't. One thing I meant to mention at the beginning that we've done on this webinar that we haven't always done in the past is we've included both OSHA and MSHA in this crisis management plan, because the overall plan is similar. There are obviously the few distinctions depending on which if you're regulated under MSHA versus OSHA. So you'll hear me from time to time refer to one or the other, but that's why, because we've included both, in this kind of overarching crisis management plan. The second is evaluation of applicable laws. So, that's, again, are you regulated under MSHA? Are you regulated under OSHA? Do you have EPA concerns? Do you have a state mine inspector? Are you going to have a local sheriff that may be involved? So it's evaluating what laws apply to your facility. One point in this is most of this presentation is focused on either the Mine Act or the OSH Act, but we do try to, raise the issue of other liability areas so that to include those in your plan. Third point here is facility audits. So, similar, like I said, to the job hazard analysis, is making these audits ahead of time, to determine, where do you think you're most at risk with your organization. The second part of this is having a plan that assigns responsibility to key positions. So I find that to be a really important part of the plan, because a lot of times, especially your people at the site, they want to feel needed. They want a job. They want something to do. Everyone wants to be helping when this happens. And so if you have your team in place and people know their role, I find that that's very beneficial. So you're going to have someone, who's going to be your interface with your agencies, whether that's OSHA or MSHA. Is that going to be an outside legal counsel or someone at your site? Which is your team that's going to be involved in rescue and recovery? And that's their focus on, especially if you're dealing in an MSHA regulated site, in a mine, and you may be dealing with a truck that's down in a pit, and that's going to be a process. Document control, we'll talk a lot about this. Who's your document person? Make it one person that's going to give the documents to whatever agency you're dealing with, and everyone knows it's got to go through that person. That's how you make sure that, documents that you don't know exist, get sent out there that you may not know. Internal investigation, who's going to run that? Is legal counsel going to be involved? Are you going to have consultants? Family and survivor assistance. A lot of times for companies, this can be a really good HR person who's very good at dealing with family members and listening to them and helping them through this. Or are you going to need to bring in outside services? Legal assessment of liability notification to carriers. So, who's notifying insurance? Whose role is that? Appropriate backup or contingency plans, and then media. As you know, a lot of times, depending on the size of this incident, you may have someone calling, and who knows who they end up calling, but who's your media person, everything should get directed to. So having this set up ahead of time helps everyone know where they fit in, what their role is, and people aren't trying to take on roles that they shouldn't, especially, for example, the media. So overlapping jurisdiction. We just wanted to point out here that, by doing this internal assessment, that can help you know ahead of time what all agencies you may have to notify and that you may be dealing with during the time of crisis. And knowing that ahead of time is very helpful. One thing we want to point out here is assume that any documents that you give to one agency are going to make it to the other. And potentially if there would be, as I mentioned later on, if there could be a tort suit down the road, they could also make it in the hands of a plaintiff's attorney. So any document that gets sent out, you should assume is basically a publicly available document. The last point here on notification, we'll talk about that a little bit more as it relates to MSHA and OSHA, but you want to have your notification requirements because, if you're an organization that has both MSHA and OSHA, depending on which site, you have different notification timeframes and requirements for that. And also being aware with EPA or DOT if they would come into effect for your site. Your liability assessment is when you're making your notification, having this assessment of what has occurred, what type of injury are you dealing with. For those of you regulated under MSHA, you typically have 15 minutes to make that call, based on the definition of an accident or your dirty dozen, that we'll talk just briefly about. But assessing the potential, any compliance issues or enforcement actions with your agents. And so, that's something that happens typically through your internal investigation, and many times with legal counsel involved, is are you dealing with an agent that may have individual liability, and is there going to be the need for separate legal counsel? Many times that's a decision that's going to be very fact-specific based on the circumstances, but at least having that as a question that gets asked in your plan, make sure that it doesn't get overlooked before it's, could be too late and you're down the road a little bit. Part of this liability assessment is potential tort issues. As you know, most employers have protection under workers' comp exclusivity. If you're dealing with a site with contractors, can you still be covered under the statutory employer doctrine in various states? Or are you working in states such as West Virginia, where many times there's deliberate intent suits that people sue outside of workers' comp? There's also case law in Wyoming that permits you to sue around workers' comp. So, is being aware of that issue of are we going to have a potential tort liability depending on the facts here. If we, was it our employee, was it someone else's employee? Part of this liability assessment is product liability claims against third parties. For example, was this an accident where the parties or the agencies involved are worried that, for example, we had a brake failure on a truck? And if you're dealing with a brake failure, now you have a manufacturer of that equipment who's going to be very interested in whether there was a brake failure. So you've got that potential that while that claim may not directly involve you, for example, that would typically be your employee suing the manufacturer of that truck for equipment failure. The point is you have to be aware of that concern, because you as the employer and the owner of that truck are the ones that are going to get contacted by the equipment manufacturer to be part of any investigation or any kind of equipment inspections that occurs. So that's another, just a question to be asking of, is that a concern here? Especially if you're dealing with any failure of equipment, that should always trigger in your mind, we've got to be concerned about equipment manufacturers. And one point of note here we've noticed recently is that, a lot of times your site people have close relationships with a local equipment manufacturer, and that's just a necessity of the business. At the time that an incident happens, if there is any suspect or any inclination of equipment failure, that equipment manufacturer's interest becomes very different. And so that's where your site people need to be alerted that, now the equipment manufacturer has a little bit different interest in wanting to come in and look at equipment. So that's where, whoever is going to be responsible for working with those third parties or addressing any third-party requests to come on site and address equipment needs to be, cognizant of those issues. Or any contractual agreements. If you're dealing especially with a contractor, is there indemnification agreements? So let's just talk briefly about the notification, because as most of you know, if the notification doesn't occur within the appropriate time frame, whether you're MSHA regulated or OSHA regulated, that's pretty much an automatic citation from either agency. So MSHA, as those of you under MSHA regulated sites know, this is an immediate notification within your 15 minutes for your definition of accidents. 50.2H lists your dirty dozen. We've just put 4 up here. These are, I would say, the 4 most common reasons that we end up immediately calling MSHA, but it is the list of 12, the way accident is defined for immediate notification. With OSHA, it's the new reporting requirements that go into effect January 1 of 2015. So we've put those on here since, we're getting close to the end of the year. Employers still must notify OSHA within 8 hours if an employee is killed on the job, so if there's a fatality. However, the new part of the rule is the second bullet here, is that employers must notify OSHA within 24 hours if an employee suffers a work-related hospitalization, amputation, or loss of an eye. And this is, like I said, goes into effect January 1 for federal OSHA. It will eventually be rolled out to all the states, but the dates on your state plan states, could be a little bit later than January 1. We've always used the acronym for OSHA-regulated sites, a FATCAT, which was a fatality and a catastrophe, as kind of a shorthand way for employers to remember when they needed to notify OSHA. So we've been trying to come up with something to be remembered as easily as that, and so far all we've come up with is FAT-HAL. So I'm not sure that's as easy, but if you remember that movie Shallow Hal a few years ago, so we've come up with FAT-HAL, which is the hospitalization, amputation, loss of an eye. So we're still working on it, but that's what we've got so far, to try to come up with an easy way to remember it. So So we'll see where that goes. One point on this notification, we had a case a few years ago where the police, actually, this was an OSHA-regulated site, the police had told the employer that they would take care of notifying OSHA about the fatality, and it was middle of the night, and the employer says, okay, great. Well, the police never did, and the employer ended up getting a citation for failure to notify. And even though, our defense was, look, the police had said they would do it, OSHA's response was, it's ultimately the employer's responsibility. So I just throw that out there as a caution that, if another agency tells you they'll do it, you still need to do it. It is ultimately the employer's responsibility to do it. So who do you call? Obviously the appropriate MSHA office or the area office of OSHA, depending on which one you're regulated under, but also company management. This is where a lot of sites will have, a list of numbers that get called in the event of a serious accident or fatality. Counsel, whether that's in-house counsel or outside counsel. Affected families of the employees. This is typically going to be the person who's going to be the contact, in your crisis management plan, who's your contact for families of employees that have been affected. That doesn't mean just the victim, but could also be maybe those that work closely with that person. But who's going to be your contact, and when does that, you want that notification to happen, obviously, before media contact makes it out. Some other immediate concerns, as we mentioned before, as part of the plan, the rescue and recovery. Local sheriff could be involved there. Your scene and equipment preservation. For those of you on MSHA-regulated sites, as you know, they're going to issue you an order that's going to put the accident site down. You're not going to, be able to even enter that site. But that's something, to be aware of with the equipment preservation, making sure that no one, disrupts the scene. The media and the insurance. Again, it's having these overarching ideas in your crisis management plan of who's your point person, and then how you're going to handle the contact and how you're going to handle in these subject areas. So let's talk a little bit about moving now from this initial notification after something's happened. You know which people you need to notify, who's in place to cover what area. Now you're moving to an investigation phase. For those of you regulated under the Mine Act, you are required to conduct your own investigations of all accidents and occupational injuries. Involving legal counsel can help protect some aspects of that through work product or attorney-client privilege. So that is one benefit of having counsel involved in the investigation phase, other than just a shameless plug from your outside counsel. But from an OSHA-regulated site, OSHA does not have a general regulation always requiring an employer to conduct an investigation of an accident or occupational injury like MSHA does. There are certain regulations that require it. For example, PSM is one of those that requires an employer to investigate catastrophic releases and such. So that would be where, when you're conducting that facility and process analysis, you're looking at, do we have any regulations that require us to? We actually had one case, a fatality case up in Alaska on a drill rig, where the employer made the decision not to do its own internal investigation at the time of the incident. And I will talk a little bit more about that, I think in a couple slides, because that actually ended up proving to their benefit, because the OSHA inspector did not want to come back up to the site up in the middle of nowhere and take more interviews. And he kept trying to get the employers to do, he tried to get the employer to do his job for him and to conduct its own investigation and just give them their results. And so they took the position that they weren't going to do one, and there was no requirement to do that. So in that case, that proved to their benefit. So it's something to think about. Most employers want to do one in order to get to the root cause, but this was just a decision made to at least delay it, because there was no reason, based on the circumstances, they didn't have to do it right away. The investigation. So MSHA's authority to investigate, the Mine Act grants them broad authority to enter on mine property. This is a warrantless requirement, warrantless entry. They always have the right to come on the property and determine what measures need to be taken. This is, done through the use of a 103J and then a 103K order that actually puts the site down. Most of you under the Mine Act, probably have experiences at some point, even if you haven't had a serious incident. But they've got the authority to come on site and really run the investigation, which is why it's important to decide who will be your point person that's interacting directly with the MSHA inspectors. From OSHA's authority, they do not have the right to come on site without permission or consent. So warrants would have to be obtained. However, if there's been a serious incident or a serious accident, most employers are letting them on site because they're going to be able to get a warrant to get on site. Oh, hold on one second. We got a question, but I got to try to click on it so I can see what it is. We've got a question, so I'll take a break because I'll take the question now because we're talking about the investigation here. The question was, can counsel be in-house or does it always have to be external? And I think it can be in-house, and this would be my only caution, is that you want to make sure that your in-house counsel is in fact wearing the legal hat when they're on site and that they're not wearing a business hat. And I say that because that's where waivers of privilege come up, is that the agency argues, well, the in-house counsel here was actually acting in an operational or a business manner in helping conduct this root cause analysis versus a legal manner, and so therefore, we think that what they were doing shouldn't be covered by the privilege. So that's the only risk there. But yeah, I think it can be both. It could be in-house or external. I think it's just you just have to be aware of, make it clear of which hat they're in fact wearing. All right, and then so let me go back to this slide here, OSHA, that warrants have to be conducted or warrants have to be obtained unless there's an exception to the warrant requirement. We got a question, which is what are the more significant exceptions under OSHA to the warrant requirement? So typically your primary exception is going to be oh goodness, I just lost the word. The open site exception. I'm trying to think of the technical term here, but it's technically where they pull up on site and they can see the site from the road. So, example, a construction site. Plain view. There we go. I had to go back to criminal law there for a second. So the plain view exception. So they pull up to a construction site and they can see what's happening from the other side of the road. They don't need a warrant at that time. Oil and gas sites could be similar. You've got a drill site. They can drive up on the road and they can see what's going on from the road. They could sit out there and take photos and videos. So that plain view exception, that's going to be your primary exception to the warrant requirement. It's typically your plain view. If they have to go get a warrant, usually it's based on an accident or a complaint. Those are pretty much going to be automatically granted to them. I've only seen the warrant requirement enforced by employers where OSHA was just almost stopping by because they wanted to check things out. So there was no complaint, there was no accident, there was no, there wasn't even like an emphasis program. And so in those situations, that's where OSHA would have to justify it. But otherwise, in this type of situation with a crisis, it's going to be granted to them. Go back to here. Oops. Hold on, I'm just having trouble clicking. Hold on one second. Okay, let me see if I can click down here. Just having trouble moving forward again. There we go. All right. So the investigation team. This is part of in your plan of who you want to include. Obviously, you're going to have someone from the agency. It may include some specialist in ventilation or electrical standards, depending on what's at issue. MSHA may bring in a specialist. On an MSHA side, if you have a serious accident or fatality, they may bring in what's called a special investigator, and this person is looking for potential civil or criminal liability by agents of the company, by management personnel. Part of your investigation team, whether you're under MSHA or OSHA site, is management representative. Who is going to be on that walk around? Typically it's the same person who's interfacing with the agency. And then your employee representative, especially if you're on union sites, you're going to have employee representatives participating in the process. The collection of evidence. Neither MSHA nor OSHA can take evidence off your site without a warrant or agreement. But sometimes it may be necessary to remove evidence, and that may be something that you come to an agreement on. If that does occur, you really need to maintain the chain of custody records on any evidence that comes off your site. And that could be very important down the road if in your plan, you've determined that there could be the potential for tort liability, not just against your company, but third-party claims. For example, your employee suing an equipment manufacturer. So that's where, that gets really important. If any destructive testing is necessary, meaning, let's say, again, the brake failure example, you've got to get in and they're going to tear those brakes apart and they're going to look at them. It's important as part of this investigation team to agree on the laboratory or facility that's going to do the work and make arrangements that your expert consultant is going to participate and at least watch in that process. By having, especially when you get to a point that there's destructive testing happening, as in-house counsel or outside counsel, that's not our expertise. We can't tell if the way that agency investigator is breaking the brakes down or what testing he's doing, if he's doing it properly. And so that's where it's important to have an outside consultant who's documenting all the stages in the process, and he's documenting, what tests are being done. Because if something is done incorrectly or improperly, he's going to know that. And if there's litigation down the road, he's going to be able to testify. He or she's going to be able to testify, I was there at the time. This is the testing that took place. It was improper for these reasons. Or I was there and they didn't do this testing. I asked them to do it and they didn't want to do it. So that's really valuable testimony if you get into litigation down the road that you can't recreate after the fact. Either someone's there participating in the investigation, getting that type of evidence, collecting it, documenting the process, or there's no one there to do it. So I think that's, whenever you have an incident that involves some type of equipment and there's going to be testing, having someone there who's knowledgeable is helpful. One question that comes up, or that has come up, is can you use inside experts? So a lot of you have, maintenance people that are highly knowledgeable on your equipment. And I think they should participate, but, as we all know, if you get into litigation down the road, that outside consultant's testimony typically carries more weight than your in-house employee. So that's the only caution I give there. And that may be, and you may make that call as to whether you can use an in-house maintenance person or if you need to bring in an outside consultant based on how serious the incident is, or based on how complicated the process is. But that's the only caution I give, is that if you do wind up in litigation down the road, whether that's with agency litigation or that's tort litigation, having that outside consultant who can opine about what happened at the time can be valuable. Inspection of records. This is something that should always be part of the crisis management plan. As I mentioned in the beginning, having that point person who's the one who's giving out documents is really critical. In those investigations I've been a part of where we've had one point person on documents, it just makes the process so much smoother and cleaner, because everybody knows that no document gets sent out outside the company without going through that one person, and that one person, has all the parameters of what's going out and what's not going out. And that can be someone inside your company. Typically they're working closely with legal counsel, and we're advising them on what can go out, what can't. But it can be someone within your company who's really organized, maybe good at spreadsheets. A lot of times we track all this in like an Excel spreadsheet. But MSHA is permitted to review any records which you keep under the Mine Act. Similar to OSHA, they're going to request records you have under the OSHA Act, like your OSHA logs. I mean, that's something, anytime OSHA comes into for an investigation, especially an incident that's happened, they're going to want your logs, and they're going to want your training records. MSHA the same way. They're going to want your safety programs. They may want, whatever policy you have that applies. Those are pretty much givens as soon as they walk in the door. There's other documents that they can request as well, and those that aren't necessarily required to be maintained under the Act. And that's where, I think legal counsel can help you make a judgment as to what do you want to voluntarily produce, what we call these non-required records. And I put up here on the last bullet point, analyze whether the request is reasonably related to the incident. It's a little bit of an oversimplification maybe of the analysis that you do, but for purposes here, I felt like that kind of boiled it down to the key point of, is it reasonably related? Because you're going to end up producing a lot of documents, and the bigger the incident, the more documents you're going to end up producing. And there may be times, depending on the case. For example, we've had some fatality investigations where OSHA simply says, give me your training records, and the employer comes to me and says, I don't have any nice sheets where it says employee was trained on policy 1 through 10, and we've checked them off. So that's where I say, okay, well, training records are good for us to have. So let's think broadly, and let's think about were there weekly safety meetings that this employee attended? Were there monthly safety meetings? Were there tailgate meetings? So occasionally you want to produce documents because that's helpful to you, but those are the kind of discussions that you have, during the investigation. One other key part is witness interviews. Interviews are used by, both MSHA and OSHA as the device to gather their information. I mean, that's pretty obvious. What are their objectives? This is, we've tried to boil it down here to about 5 bullet points of really, from what we see they're trying to do through these questions. And a lot of times people feel like, well, they're just trying to figure out what happened. And not trying to be cynical, but that's not all they're trying to do. So, they are trying to determine the cause, but they're also looking for evidence of violations, not just related to the incident, but potentially other violations that may exist at your site. They're trying to evaluate inconsistent statements, so are employees giving different stories. Trying to determine whether the accident happened from a knowing or willful violation. Was there any willful, intentional type conduct here? And then try to discover evidence of a history of unlawful activities or practices. Those are questions about, do they feel comfortable reporting safety violations? Has this happened in the past? Have you ever seen this happen? So, there's a lot of different type of questions, but this is where we see really the goal of these interviews from any agency. In addition to the agencies doing interviews, we do recommend that the company take interviews of the employees. And some employers like to do this without legal counsel, and other times, we as legal counsel are involved in those interviews. And one benefit, I think, of having legal counsel take the interview is you can do a confidential investigation. So if I'm doing the interview of an employee, my notes are going to be protected by the Attorney Work Product Doctrine. So that's helpful. I was talking a little bit ago about that investigation in Alaska, and the company that had chosen with the drill rig accident to not conduct an investigation at the time. I actually came in and interviewed all the employees so that we could determine what from a legal perspective, what we thought happened so we could defend them on the OSHA violations. And the OSHA inspector actually tried to subpoena my notes because, as I said, he didn't want to go back up and re-interview employees, and the company did not do a separate investigation. And that subpoena, once it got kicked over to the Attorney General in Alaska, and I talked with her, and she agreed that that was work product and she wasn't going to get my notes. Because I informed her, I said, these are solely just my notes. I was the only one interviewing this employee. So that was a case where it really did help us the way that we ended up running that investigation. One thing that council can do by participating in the interviews of employees that agencies take, so MSHA is interviewing the employee and legal counsel sits in, is kind of monitor the process, making sure that it's fair, the witness isn't being improperly led, try to ensure the statements that get prepared are complete and accurate, reviewing those, comparing those against our notes. That can be helpful. And the last bullet here is determine if a conflict exists. You see this come up, from an agent. If you have someone who is your agent, but he or she has violated policy, and there may be a conflict that exists between the company and that agent, and try to identify that quickly in the process, especially if you're dealing with a willful fatality on an OSHA site, the potential of any criminal issues that can come from that, and making sure that employee understands, because there may be a situation where you need to bring in separate counsel for that employee. Hold on, here we got one question. Let me see here. Let's see. Legal counsel. The question is if legal counsel directs a company management employee to do the interviews, are the interviews protected? I would say yes, generally. So generally, yes. If it's being done at the direction of legal counsel, case law would say that should be protected under, that's being done at the direction of attorney. The only caveat is if those, let's say legal counsel directs management to go take these statements and interviews, and then those interviews and statements get put into a root cause analysis that business unit then uses, to try to obviously learn from the incident, which is important. At that point, you're probably going to lose your privilege over it, because now they're being used on a business side on a root cause analysis. They're not being used in litigation. So that's my only caution on it. I think it's okay to have legal counsel direct management to do it, but then keep those as part of the litigation process. Don't then loop that back through the root cause, which can be tough, right? Because are you going to want to take 2 interviews of the same person? So that can be where having legal counsel talk to people separately, you can really keep things separate. And it may be that at the end of the day, after they take the interview, you're not worried about eventually keeping it privileged. So initially, legal counsel directs the management employee to take them. That's keeping the privilege. And then once you get the statements, you're okay, and they end up part of the root cause. So, but yeah, that's a good question, because you can direct them. It's just, I just caution as to kind of where those statements go after they're taken. Go back over here. So this kind of follows what we were just talking about. Written statements from the employee may become evidence. Especially, this usually happens where right after the incident, your guys on site say, everybody sit down and write down exactly what you saw. Most of the time, that statement's going to become evidence. It can be different if legal counsel has already been notified, even if it's in-house counsel, and the in-house counsel says, go and have them write down the statements and then send them to me, meaning send them to legal counsel. But yeah, it depends on who's involved at that time. One caution that I give is if you're going to ask employees to sit down and write statements out like that, make sure that whoever tells them that says, please just tell us the facts that you saw. We don't need opinions right now or that kind of thing, just the facts. My preference is to always have someone interview them and take notes versus having them write statements, obviously, because then the person taking the notes, if they're direction at legal counsel, we can try to protect those. Because we don't control what the employee may write in their statement. They may write, this was all my fault, because they feel guilty. So that's something to consider. I know companies, have different policies on how they like to handle that, but there's cautions on both sides. One issue to think about, though, is emotions. Whoever's asking them to do that needs to really evaluate whether that person is emotionally ready to make that statement, because we've actually had to push back on some investigators for OSHA and MSHA when they want to interview someone if emotionally that person's not ready to do it. And there have been, incidents where, I mean, people will tell you they killed Kennedy because they're just so emotional at that time. So that's something that has to be evaluated. We broke down here the MSHA investigation interviews versus OSHA because they are a little bit different, just to put them up here. The employee being interviewed. For MSHA, they have the right to counsel. They have, the right to have, or the presence of a management employee. So a lot of times, an hourly employee is okay with his supervisor sitting in. He's got the right to discontinue it at any time, refuse to answer a question, refuse to permit the tape recording, or even refuse to sign a statement. MSHA interviews, unless MSHA wants to open up a hearing like they did in Upper Big Branch, they don't have subpoena power to interview. So 99.9% of the time when they're on site doing these incident investigations, these are all voluntary, which is why, they've got the right to refuse to answer questions or stop it at any time. We make that separate from OSHA because those of you on OSHA sites are aware OSHA does have subpoena power. So typically an employee's refusal to talk will result in a subpoena being issued. We put here these bullet points typically relate to the hourly employee because I think that's where the most questions come up. Most people understand with agents or management employees, you have the right to have counsel present for those. But for your hourly employees, those can be done in private. The employee may request to have someone present, but typically management's not going to be permitted to be there. The employee can request that, but a lot of times I've had OSHA say, no, then I'll talk to you later, because they really don't want to have management there when they talk to the hourly employee. So I still take the view that it's ultimately, unless there is a subpoena issued, it is still the hourly employee's interview, and it's still their decision how they want to conduct a voluntary interview. But there is pushback on that. The last topic I want to talk about here today is the privileges. And these next slides, I'll warn you when you get them, there's a lot of information on them. I'm not going to sit here and read them to you, but we just put a lot in the slides so that you would have it later when you get it if you need to look at it. But this goes to a little bit what we were talking about earlier. Oh, hold on one second. We've got a question before I move on to the next topic. Let me see. The question is that MSHA special investigators are trained to write down what was said after the interview, and then this sometimes becomes a position statement. How is the best way to handle that? So I think if I understand the question, with the MSHA interviews, they usually do it one of two ways. So a lot of times they will write down everything that employee says in a statement. They will then send it to the employee being interviewed, ask them to review it and sign it. And in that case, the employee gets the chance to review it, correct it, and sign it. There's other cases where what the special investigator will do is he will take notes of what is said, and then those notes get put into a position statement that you don't see, that doesn't get sent to the employee to review. So I think what we typically recommend is, one, it's ultimately the employee's call. So we advise the employee, even the management employee, that is their decision whether or not they want the interview to be recorded, we're talking about MSHA right now, or whether or not they want to sign a statement. And let them make that decision, because you don't want to be interfering in the investigation. They really need to make that decision. If they decide they don't want to record it, but they're fine to review a statement afterwards, then what I recommend is have MSHA send the statement when they're done. You compare it with your notes or whoever sat in on the interview. The employee reviews it. You revise it so it's so you're comfortable with it, and at that point, it's okay for, I recommend it's okay for them to sign it if they're comfortable with it. I've had some employees that they get the statement and they don't agree with it, they don't want to revise it, so they simply don't sign it, and that's their decision. But most of the time, we're able to revise it and, make additions or things that we don't think are, entirely exactly what was said, and then able to sign it and send that in. So, I think the best way to handle it is really just to be cautious that whatever statement you review, if it's not accurate, don't sign it. And if you can't fix it enough to make it accurate, if you really think it's not, then don't sign it. And typically from the employer side, we recommend filing your own position paper whenever there's a special investigation that sums up what you see as the employee's statement. Does that answer the question? If it doesn't, I'd be happy to talk with you more about it later. Great. Okay, so let's talk about privileges. And first, the attorney-client privilege. So, as we said here, these slides are chock full of information, so we'll just kind of hit the high points a little bit. But the purpose of the attorney-client privilege is to have this full and frank disclosure. So it's that, you as the client can tell the attorney, whatever you need to in this representative capacity and keeping those communications protected from disclosure. What's important is that confidentiality can be waived. So that's where I was saying with those statements, if they get used later in a root cause analysis that goes to the whole business unit, you may be waiving some of your confidentiality. The second is the attorney work product privilege. So this is designed to protect the physical work that gets prepared in anticipation of litigation. So for example, when I gave the example of the fatality up in Alaska, and it was my notes from the interviews, those were prepared in anticipation of litigation in order to defend the company against the OSHA citations, or what we anticipated were going to be the OSHA citations. So those were ultimately protected by the attorney work product privilege. This sentence here goes to the question we had earlier, that the documents or information must be gathered at the direction of an attorney. So that's where you don't want to have your business person gathering statements if there's no legal counsel involved. This is the difference between kind of an attorney litigation summary versus a root cause analysis. Is this summary being done in anticipation of litigation, or is it being done to share with all the business units in order to try to make sure this doesn't happen again? There's ultimately valid reasons for root cause analysis. It's just being aware that what's in those documents may not stay protected even if they were in the beginning. Whoops. Sorry about that. Wrong button. Okay. Next one is privileges, knowing, where they can be lost. So, as we talked about, where an investigation is done at the direction of counsel, the different privileges can apply to the materials that get generated and the information learned. The second bullet here is interesting. We talk about the consequences of hiring experts and consultants without the assistance of counsel. Typically, when a crisis happens, serious incident fatality, we as outside counsel retain the consultant on your behalf. And we do that because we want to keep what they know and what they're doing privileged. And we do that, and it's actually worked pretty successfully, because I'm obviously not an equipment expert. So I can't determine why that, the wiring quit working or what was faulty on it. So I need that consultant to go in and look at it for me and tell me what happened, so I can now defend you in any litigation. Those are privileged conversations. That expert, we may decide what he tells us. If it's bad, we may never use him. He may not, become a testifying expert down the road. Now, if he would become a testifying expert, obviously what he knows and what he learned would be disclosed, but that would be a decision that we would make to disclose him. However, if you retain that consultant directly, the business brings in a consultant and there's no legal counsel involved, then I think you'd have I think it'd be really hard to argue anything that they do is privileged at any time, because they're really being brought in from the business side, not from a legal side. So that's the distinction there, that a lot of times we like to bring in those consultants from the legal side, because you never know in the beginning what you're going to learn. You may be all good information, but you just don't know in the beginning. As we say here, neither is absolute. That's why we say things can be waived, depending, there's a lot of case law around this issue, but, my goal here today was just to raise these issues so that when you're creating your plan and you're deciding who's going to do what, who's going to bring in consultants, when's legal going to be involved, that this is one of the issues you're thinking about. So lastly here, I just got some pitfalls and some strategies to consider. First is, production of documents to one agency may waive it to all third parties. I think I'd mentioned that before. We've seen documents that we've given to OSHA, and then they get produced in tort litigation from a plaintiff months later. And you're like, oh, that's interesting. Where'd you get that document? So assume once it's out, it's out. Establish a document control system. As I've mentioned, that's really important. Who's the gatekeeper? Who's controlling those documents? Manage e-discovery, and then avoid spoliation. So I've got a couple slides on each of these points with some tips so you can have those for your plan. But this first on this document control system, having a team, or a person who's doing that. Having all requests in writing, I think that's really important because I've seen where inspectors are, they're going through the inspection or they're walking through a site going, yeah, give me that document. Oh, and you got that issue? You got confined space? Yeah, I want to see that. I want to see that policy too. Someone needs to be writing that down so at the end of the day you can go through that list and make sure you have everything. That's really important, and, because then you don't get into an argument that you failed to produce something. Keeping all the documents in a central location is helpful. If you're able to base stamp, that's great. A lot of times that's not possible. So many times I will tell an employer, if you don't have the opportunity to number the documents, in the bottom right-hand corner before you send them out, if you've got a document control system, we've got one person who's making a copy of that set of documents, and then they're producing it to OSHA, and then it goes in the production file. So we're keeping an exact copy of what's being handed to the MSHA or OSHA inspector, and then we usually have an Excel spreadsheet that's tracking it. So, we've got some tracking systems if you're not able to get them numbered. Limiting the number of copies on which privilege is claimed is very important. As we talked about, that goes to the waiver issue. If it gets out to a wide group of people, plaintiff's attorneys, the agency, Department of Labor is going to argue that any privilege was waived over it. Part of this is on privileged documents, limiting who's getting those and stamping those or somehow keeping them separate. One thing that we even do here on our documents is they go in a red folder so that even when I'm looking at my documents, I can tell immediately what I've withheld on privilege grounds. So some way that you're designating what's being withheld on privilege so it doesn't inadvertently get sent out. Managing e-discovery, this is a whole topic in and of itself. I mention it here because it's just a legal hold. In this first bullet here, once you become involved in litigation or you anticipate that litigation may occur, your obligation to preserve records starts. And that's what's really important here is, you've got to turn off automatic deletion systems, get the legal hold memo out. That's usually something in-house counsel does, but we've raised that here because it is an important issue. One moment here, let me see. We've got a question here. Let me see. We've got increasingly, we are seeing MSHA ALJs issuing pre-hearing orders that dismiss the notion of attorney-client privilege work product doctrine on notes and information at the outset of MSHA litigation. How are you handling this issue? So I think what you're referring to and what I've seen in some pre-hearing orders is some judges like to say that notes taken by the company during the walk-around with an MSHA inspector are not privileged. And so they say, well, you're going to get the inspector's notes. Any notes taken at that time by the company is also not privileged. We've taken the position if it's a regular EO1 inspection, so it's your regular, one of your regular inspections you have, and it's your legal counsel's not involved, and it's one of your guys walking around taking notes on the inspection, then I think they've got a pretty good point that arguably that's not going to be protected by attorney privilege. However, if we've had a complaint, if you've had an incident, you've had something where you've had to notify your either in-house counsel or outside counsel, and they've now directed you to take notes to prepare the case because you know something's coming, then I think that in that situation, those notes are going to be protected by privilege. So I think those statements in the pre-hearing orders, I think the judges, and there are only one couple that are putting that out there, I think you still have to do an analysis internally and with your legal counsel as to whether, based on the circumstances, no, we think these notes are protected by privilege, and you have to disagree with the notion that, yeah, just because they're taken on the inspection, they're automatically going to be produced. It really, to me, depends on what the circumstances are. So that's something, before you would turn over any company notes taken during an inspection, have the discussion with counsel as to what were the circumstances as to why they were taken, and can we claim privilege? Because, yeah, to me, I think a judge, even though they're putting those pre-hearing orders, they can't make that blanket statement. They still have to evaluate what the factors are. If you want, I'm happy to talk further about that issue. I think that's there's a pretty involved issue on that if you want to talk further afterwards about that. Spoliation, that's last point here, is it allows, most people know what this means. It allows courts to give an inference that if the evidence was destroyed, that it would have been unfavorable to the party who destroyed it. So both these slides raise this issue for you. My caution is it doesn't apply just to documents. It also applies to physical evidence. So, when you're dealing with destructive testing of equipment, you could have that come up if you've got an equipment manufacturer who wants to participate or at least see the testing that's going on. That's a consideration you've got to make, that do you need to let that equipment manufacturer come in and witness the testing so that you avoid any spoliation issues down the road, that if they would get sued by the employee in tort, that they didn't have a chance to test the equipment themselves. So I raise that issue just that, it can apply both to documents, like if a litigation hold is not sent out, but also to physical evidence if there's testing that goes on. So it's just something to be aware of. And lastly here, we just got a couple minutes. Mention here is the media coverage, interaction with families, being sensitivity to the communication. When something has happened, the perception in the media is that the companies don't care. Having a timely response is very key, both to the family and to the media. And this would be from having if you have an HR person who's really good at being the resource for not just the victim's family, but other employees, bringing in maybe an EAP assistance person and having them available for your employees. That goes a long way, I think, for employees when you say, you know what, we've got this counselor here today. If you want to go talk to them, you can do that, because a lot of employees, they have a lot of emotions, especially even if it's just, a single person fatality. If they knew that person, there's a lot of emotions there. And if you're working in, in an area where, you need employees to keep their minds on the job, which most of you, that's your business. Your employees have got to have their mind on the job. You want to make sure you're taking care of that issue. So it's having someone who's dealing with the media, making sure that there is a response, it's timely, it's being sensitive, but also having someone who is coordinating from the emotional side. What's your message going to say? You can, a lot of times we're helping clients to try to draft those messages, but you want to control the message. You don't want the media to control. There may be times that you're consulting with professionals and they're telling you, right now we want to say we're looking into this. Our condolences to the families involved. No other comment at this time. There may be reasons to make that, but these are just considerations for you. So that concludes our webinar today. I think we've only got about a minute left here. I tried to pick up the questions as we were going so that they, were on topic with what we were covering. I'm happy to stay on, and if anyone has any additional questions, if you want to talk further about something, feel free to contact me. Let me go, I think, let me see. I was thinking if I get to, I may have to go all the way back. I'll go back to the beginning. I think it's got my contact information. If you want to contact me via email or phone number, happy to talk further about, there we go, about any of these issues, or any, if you deal with other safety and health lawyers in any of our offices, pretty much all of us are very well versed in this crisis management, so any of us can answer any of your questions. So, I got one question. Let me see, I think. Can I get a copy of the slide presentation? Yes. So Raquel will send out, she's who introduced us today, and so she's going to send out a copy of the slides, and I think a recording, although you don't have to listen to me again, but you will get a copy of the slides. But like I said, if you've got any further questions, please let me or one of the other attorneys at Jackson Kelly know, and we appreciate your participation today. Thank you.